So this video is going to cover a legal concept called causation. Hopefully you've already at least watched the actus reus video and you've got a fairly good idea about the legal act part. And it's useful if you've already watched the mens rea, the mental element part of the crime, so that you've got a fairly good handle on the physical part of the crime and the mental element of the crime. What we're looking at today, causation, the clue's in the name. We're looking at, did the defendant cause the harm to the victim or cause the outcome, depending on what particular crime it is. So what I need you to think about, this idea of causation is a chain, and you need to have a set of unbroken links that comes from the defendant's action, what the defendant actually does. So the defendant injures the victim and the outcome which takes place. So if we look at the scenario we've got here, the defendant injures the victim is injured in an ambulance crash and the victim dies. Now the defendant is certainly responsible, is the cause of the injuries, but are they the cause of the death? Now that's quite a tricky question, and the most accurate answer is, well, sort of yes, sort of no, which legally, we're going to put the correct legal terminology onto that in a moment, is the right answer. But if you had to look at that particular scenario without thinking about any of your legal knowledge and just applied your common sense, no. If the victim is injured in an ambulance crash, then the person who put them in that ambulance isn't sufficiently responsible to be responsible for their death. So this is an overview of causation, and what I'd like you to do on this slide is pause the video for a moment, and you need to make a note of each of these 3 points. You need to leave some gaps around it, because what you're going to do is add in some case law and some terminology and things like that around it. But this, in a nutshell, is everything that you need to know about causation. So the first part that we need to look at are the tests for causation. There are 2 tests, and they must come in this order, because the first one, factual causation, is much easier to prove. It's got a much lower standard, so it's much easier to say that somebody is the factual cause. And the test for seeing whether somebody is the factual cause is we have to look at, but for the defendant's action, the harm would not have occurred. You can, in your own mind, you must use the legal terminology, but in your own mind, you can say, if it were not for, instead of saying but for, or if it weren't for this, then this wouldn't have happened. So the second part is legal causation. So once you've established that if it weren't for what they did, but for what they did, the harm wouldn't have occurred, we then need to look at the higher standard, legal causation. And what we are looking at here is, was the defendant's act the operative and substantial cause of the result? And what that means is, was it the main cause? Was it, if you apply your common sense, the real cause, if you will? So those are the 2 tests you've got to prove. But for the defendant's action, the harm would not have occurred to the victim, and that the defendant's act was the operative and substantial cause of the result, so the main cause. The third part is looking at whether this chain of causation has been broken by anything. So the 2 tests establish that this chain exists, that there is a chain, and now we need to look and see whether it is broken. And what the things that could sever this link, there are 3 things that we need to look at. The first one is an act of God or a naturally occurring event. The second one is the act of a third party, and for our purposes we are looking at medical negligence, poorly carried out medical treatment. And the third one is the victim's own act, which is, for our purposes, the victim escaping from the threat that the defendant poses. So, if you haven't done so already, take a note of those. You're going to want to leave about 5 centimetres between each point. So you're going to write down point 1, leave about 5 centimetres, point 2, 5 centimetres, point 3, 5 centimetres, just so that you can fit in all the notes, and then we'll move on to the next slide. So I'm assuming that you've got your notes all sorted, and we'll have a look in more detail at each individual part. So factual causation, just to remind you, this is the first thing that prosecution must prove, and it must always come first because it's an easier test to prove than legal causation. And the test is, and you've got to say it like this, it's called the but-for test. And the way that it's used is, but for the defendant's act, the harm would not have occurred. So that might be a little bit tricky, but you may find it easier to have a look at the way that it's presented in a couple of cases. So first of all, we have the case of R and White. In this case, the defendant tried to kill his mother by putting poison in her drink. His mother died shortly afterwards, but from a heart attack. The poison hadn't taken any effect, and therefore he wasn't guilty of murder. So the prohibited result, his mother's death, still would have occurred even without the defendant's action. So, but for White trying to poison his mother, she still would have died. So he is not the factual cause. Rest assured, although he wasn't guilty of murder because he didn't cause the death, he was guilty of attempted murder. So in the case of R and Paget, the defendant shot at the police, and when the police fired back at him, he used his girlfriend as a human shield to try and block the bullets from him. His girlfriend was killed by the shots fired by the police, but Paget himself was convicted of her manslaughter. Even though Paget didn't shoot her, Paget didn't do anything to her apart from hold her in front of himself. And the court said that, but for the defendant's actions, using his girlfriend as a human shield, she would not have died. So now that we've looked at a couple of cases, R and White, where the defendant wasn't the factual cause, R and Paget, where the defendant was the factual cause, what I would like you to do is come up with a scenario. It can be a very, very simple scenario, and apply the but-for test for yourself. So let me give you an example. I kick my friend Glenys in the shin and she has to go to hospital in the car. The car is struck by lightning on the way to the hospital and she is killed. Am I the factual cause or not? Well, but for me kicking her, she would not have been in the car and therefore she would not have died. Have a go yourself, try and come up with one where they are the factual cause and one where they aren't the factual cause. So let's move on and have a look at legal causation. Once you've proven factual causation, what we are looking at is, was the defendant's act the operative and substantial cause of the result? What we are looking at is, are they the main cause of the result? And actually, all you're going to do with legal causation is apply your common sense. So if we think back to a couple of moments ago, I gave you the scenario about I kick Glenys in the shins, she goes to the hospital in the car is struck by lightning and she dies as a result. So factual causation, but for me kicking her in the shin, she would not have been in the car and she would not have died. So I am the factual cause. But am I the operative and substantial cause of her death? Am I the main cause of her death? Well, no, I don't think that you could ever argue that I was. It's an unfortunate accident, really. So although I am liable for her initial injuries, the kick to the shin, I'm not liable for her death. Once you've established that, you need to have a look at the things that can break the chain of causation. So this is step number 3, things that can break the chain of causation. And just to remind you, we said things that can break the chain are the victim's own act, the act of a third party, and an act of God. We're going to have a look in a little bit more detail at each one of those. So the victim's own act, there are 2 cases that you need to note down next to this. The victim's own act, for our purposes, will be to do with escapes. The victim escaping from a situation that the defendant has put them in. And escapes must be reasonable and in proportion to the threat. So think of the scenario, you're sitting in a classroom and I come in and say, you have a piece of homework due by Monday, you jump out of the window and you are killed. Am I responsible for your death? Well, no, because that's not in proportion to the threat. You're comparing piece of homework due Monday with jumping out the window. If I came in with a knife and said that I was going to kill you and you jump out of the window, now that probably would be in proportion to the threat. So it all depends on what the situation the victim is faced with what they do in the circumstances. And we can see how this works in the 2 cases below, R and Roberts and R and Williams. So in the case of Roberts, the victim was injured whilst jumping out of a car. The defendant, who was driving the car, had threatened the victim, grabbed her, tried to undress her, and told her that she'd be beaten up. He'd beaten up other girls who refused to undress. The court said that in the circumstances of being given the choice, you either stay in the car and you're going to be sexually assaulted, or you jump out the car and you take your chances that way, that it's in proportion to that threat that you jump. So this didn't break the chain of causation. So although the defendant, he didn't push her, he didn't force her to jump out the car, he was the reason that she jumped. Case of R and Williams, similar-ish situation. The victim in Williams was a hitchhiker who jumped out of a moving car for no apparent reason, the court records. There was some discussion that somebody in the car was trying to take his wallet from him. The only issue with that is, think of the situation. You're in a moving car with somebody, and they take something from you. It's still in the car, you're still in the car, they're still in the car, so is it not still in your possession? Well, it's an argument to have, but the court didn't really see any reason why he felt that his wallet was going to be stolen. And when faced with the question, was it in proportion to the threat? Well, you'd get another wallet, you can get more money, you can get new credit cards. So in this particular case, the defendant's actions were not seen as being reasonably foreseeable. You wouldn't have been able to guess that that would be how he would have reacted. So this did break the chain of causation. So you've got to weigh up what might happen if you stay in that situation with what might happen if you escape. And that's what you're looking at. We also have to have a look at a concept called thin skull rule or eggshell skull rule. This is a bit of a tricky one, and it will take you a couple of reads over this to really get your head around it. What this is saying is, if your victim is particularly vulnerable for any reason, be it a health issue or a personal issue or a moral issue, you have to take your victim as you find them. It's not acceptable to say, oh, well, there was something wrong with them, or they were particularly vulnerable, or they had this thing that made them particularly special. I didn't know about it, so it's not my fault. Let's have a look at how this is illustrated in a case called Blair, and hopefully that will help you to understand. So in Blair, the victim was a Jehovah's Witness and was stabbed by the defendant. The victim was told when she got to hospital that she required a blood transfusion in order to survive, but she refused this on religious grounds and she died shortly afterwards. The defendant argues he's not responsible for the victim's death. She almost chose to die because she refused the blood. But the court rejected this argument and stated that you must take your victim as you find them. So the defendant is still responsible for the victim's death. This prevents people from using things like that as an excuse. Other things that might make people vulnerable are health issues. If you'd got somebody, for example, who was a haemophiliac, which is somebody whose blood doesn't clot if they start to bleed, then you couldn't, and you cut them and they bled to death, and somebody else without the condition wouldn't have bled to death, you can't use that as an excuse to say that you're not responsible. You cut them, this led to their death, you're liable. So, let's have a look at the act of a third party. For our purpose, what we're looking at is medical negligence. So we're trying to assess poor medical treatment. But medical negligence very, very rarely breaks the chain of causation, but it will only do so if it is palpably wrong. Now, in your own mind, you can swap that phrase for stupidly wrong. And what I want you to think about just for a moment is, why is that? If somebody gets more badly hurt or it leads to their death, and the reason was actually the medical treatment they received and not the initial injury, why should the defendant be held responsible for the whole injury, all of the harm, rather than just the particular part that they were the direct cause of? Have a think about that. So we're going to have a look at 3 cases which will hopefully get you to see why maybe that's the reason. So the first case is R and Smith. R and Smith, just so you know, is also the case which gave us the operative and substantial cause test under legal causation. So next to legal causation, you might just want to put in brackets Smith. So in this case, we have 2 soldiers who are fighting, and the victim is stabbed, and the stab wound actually pierces the victim's lung. He's taken to the medical station on the base. On the way, he is dropped not once but twice, and he receives very, very poor medical treatment. And the medical team never fully appreciated the seriousness of his injuries. They missed this pierced lung. The victim dies, and the defendant, Smith, is held responsible for his death and is convicted. The defendant appeals and is unsuccessful because he said that he wasn't responsible for the death, but that was because of the poor medical treatment. This is rejected because the original wound, the stab which caused the punctured lung, was the operative and substantial cause of the death, of the consequence. So although he was dropped, although he received very poor medical treatment, he died because he was stabbed. The defendant caused the stab wound, therefore the defendant is responsible. Next case, we have R in Cheshire. The victim is shot several times by the defendant, and the victim dies because of rare complications due to a tracheotomy. That's where you have a tube in your throat, which he had to receive after he was shot. Now, this is less straightforward than Smith because the original wound is no longer life-threatening, but it was not independent of the original gunshots. And this case held that medical treatment won't break the chain of causation unless it is completely independent of the defendant's actions. Now, in this case, yes, the victim was healing and it was no longer life-threatening, but why did he need that tracheotomy? Because of the gunshot wound, and therefore the defendant is still the operative and substantial cause. It doesn't break the chain. Now, I want you to look at the difference between the case we just looked at and this case here, which is R and Jordan. In this case, the defendant stabbed the victim, and the victim was treated really badly in hospital and died. The wound that the defendant caused was nearly completely healed, and the defendant was initially convicted of murder but successfully appealed. The victim didn't die because of the initial stab wound, but because of medical treatment which was palpably wrong, which, as we said, meant stupidly wrong. And this was sufficient to break the chain of causation. The palpably wrong part was the victim was given a drug which they were highly, highly allergic to. They had an allergic reaction, but the reaction was stabilized and it was put on their records, obviously, don't give this person this drug again. At a later point, they were given the same drug in a higher dose and they died from the allergic reaction. Now, can you see the difference between Cheshire, the tracheotomy? Yes, it went wrong, one of those things. It wasn't medical negligence, it was just very unfortunate, but necessary. And Jordan, where the mistake is stupidly wrong and should never have happened. Medical treatment will only break the chain when it is stupidly wrong, like in Jordan. Think about the consequences if the test wasn't so strict. It would lead any defendant whose victim had received medical treatment could be open to say, well, the medical treatment wasn't up to scratch. They would have been fine had they not had this many stitches, or they hadn't had this operation, or they hadn't had to wait to be seen. It would just open the floodgates to defendants trying to get away with it. So that's why the test with medical negligence is so high, and that is why it only very, very rarely breaks the chain. And finally, no cases here, an act of God. This is an intervening act that will break the chain of causation. Sometimes referred to as an act of God, sometimes referred to as a naturally occurring event. Something that is unpredictable and nobody's fault. So, as we've seen through the last few slides, we are looking at the law of causation. And we are looking first of all to establish a chain exists using the butfor test, factual causation. But for the defendant actions, the victim would not have suffered the consequence. And then the more difficult test, the legal causation, it is the defendant's action the operative and substantial cause of the harm. And then once the chain is established, is there anything that breaks it? Act of God, act of a third party, medical negligence, and the victim's own